Hold on. Let's go back on the record on State versus Lloyd. He's present with his attorneys. State Attorney's Office is present. Yes, Mr. Lineman.
There are two pieces of evidence that we overlooked in introducing to moving into evidence. Those are the photographs from Pat McKenna and the videotape. The state has no objection. Now move them into evidence.
State, no objection. All right. This is, what number are we on, 17? How many photos are there? Photo 25. These are 25 photos. It's a composite exhibit consisting of 25 photos. It's Exhibit E being introduced into evidence as exhibit number 17 by the defense. There's also a video that's attached to the exhibit. Oh, those are separate? Because it's not tagged. Is it inside the envelope? Okay. So is the tag on this one, do you know? Okay. So, and separately, Exhibit F is being introduced as defense exhibit number 18 without objection. Anything else?
Yeah, the only other thing is we still need to argue the equally available issue on us having to call Severity. Or Mr. Schwartz is prepared to argue that. They filed a motion.
Oh, the motion in limine?
Yeah.
Yeah, we can do that before we do charge conference. Mr. Schwartz? Thanks. Who's arguing for state?
I am.
Go ahead, Mr. Puxley.
But I would rely basically on what is contained in my motion as a standard motion. That involves that's on the state's failure to call it available to both sides or introduced evidence that's also available to both sides, specifically, but not limited to. I can't imagine that that's going there with the Walmart video, the text messages, Detective Sadelli's testimony, the detective case.
Okay. That it? Go ahead.
The defense has provided several cases. I don't know if the defense wants to talk about those cases and be responding to the court having to address those cases.
Let me hear from the defense first, and then I'll have you respond to their cases. Go ahead, Mr. Schwartz.
Judge, the cases that we gave you should indicate that the Halliburton rule doesn't apply when the defense actually calls a witness. So in this instance, for example, for Detective Savelli, since we called him, we are allowed to argue that the state intentionally didn't call him in order to tailor the evidence in their favor. Obviously, they can rebut that after we make that argument. But the Amos case and the Lena case were pretty clear that we are able to do that, Judge, and they're both post-Halliburton cases. I could show you where in each page, Judge. I didn't mark it, but to save you time going through them.
Okay. I'm a pretty fast reader. Hold on.
Pardon me?
I'm a pretty fast reader.
Okay.
I'll get that. Thanks. Okay, go ahead. This is just Halliburton and Amos, right? Okay, okay.
And it's just
Go ahead.
the one that explains why Halliburton doesn't apply in a case like this, where we introduce the evidence, so we call the witness.
Okay. Response, Mr. Buxman?
Your Honor, the two cases provided by the defense, Amos v. State, 618 Southern 2nd, 157, Florida Supreme Court, 1993. That case involved a situation where there are two eyewitnesses to a murder. The state called one eyewitness, presented a partial picture, and the state did not call a second eyewitness to the exact same events, thereby leaving the impression that part of the picture, or the whole picture, wasn't fully presented. Similarly, in Lena v. State, 901 Southern 2nd, 227, a third DCA from 2005, the state presented the testimony of a child sex abuse victim, which the argument was presented a part of the story. The DCF worker would have completed that story, and the defense was allowed to argue that the state failed to present a complete picture. The state fails to understand or see where Detective Savelli, what partial picture the state presented of a piece of evidence, and Detective Savelli would have then clarified the full picture. Detective Savelli's testimony may have been relevant to establish some portion of their defense, but it was not relevant to establish the rest of the picture that the state presented of something.
Mr. Buxman, the argument that you just made, would that not be the response that you're entitled to make to their argument that your failure to call Savelli was an attempt to tailor the evidence, as opposed to grounds for me to say they can't make the argument at all? I mean, there's a difference between being able to make the argument and whether the argument is going to be given any credibility by the jury, and what response that you can make to that argument.
But I believe that the defense, based on these cases, have a threshold burden to show what partial picture the state presented that had to be clarified by Detective Savelli's testimony. Otherwise, the entire Halliburton rule would be non-existent. The rule inherent, and I believe Michaels was the case cited in the state's.
Well, no, because Halliburton is when neither side calls a witness.
Yes, ma'am,
Yeah.
I agree.
So this is, that Supreme Court of Florida modified Halliburton somewhat by saying if one side calls the witness, the defense calls them, then they're entitled to make this argument. So, Ms. Schwartz, your response to their argument?
No, Judge, I think the cases are very clear. Halliburton applies in the instance you said when nobody calls them. Amos and Lena apply where one party calls the witness.
But what is it that Savelli added that the state didn't present? I'd have to look at my notes. I don't remember Detective Savelli's.
I think we're allowed to argue however we want to argue. Like you said, we'll make the argument if we want to say that he wasn't called for purposes of tailoring the case on their side, as opposed to anything that would support our self-defense argument or any other argument we make. We'll make it, and the jury will decide.
I just need you to remind me generally what it was Savelli testified to.
Mr. Lemon remembers better than me, Judge.
He was the lead investigator. He went to the
Right.
scene. That he met with the mother. He returned the gun.
Right.
Was taken from the upstairs and informed them.
Okay.
He interviewed witnesses. He relied heavily on the text communications when he was looking at the investigation, because he included text in like 13 pages of his report.
Okay, yeah, I remember. And this is Savelli's the one that arrested the niece, or the, right, okay, yeah. All right, thank you.
Your Honor, the majority of that would be hearsay if presented by the state or if attempted to be presented by the state. Whose gun is this? Well, Ms. Daniels told me it was Sade's. That's hearsay. So we're being now criticized for not calling a witness to introduce evidence that we're unable to legally introduce. And I can't explain that to the jury.
Hold on. I understand your argument, Mr. Buxman. I'm not saying that the defense is, the problem is Amos says they can do this, that they called the witness. You all didn't object to the hearsay. There was no objection from the state that all of this was hearsay. And as I recall, you introduced evidence during your case in chief that the gun belonged to Ms. Dixon, and she's the one that went and got it. Or your witnesses testified that Ms. Dixon went upstairs and got this 9mm.
Dixon testified her daughter owned the gun and that it was not in the box where it belonged.
Correct. So I think the problem that you're facing is Amos is pretty clear on its face that they can make this argument. It doesn't make any distinction about whether the argument is a good argument, a bad argument, whether it's accurate or inaccurate. That's the whole purpose of you being able to rebut it, and I will certainly give you leeway to rebut it during closing. But I think the defense is right. Is this the only, Savelli is the only issue, right? The only witness where you all are attempting to do this?
Well, I mean, actually, no, because they failed to introduce the text. We had to call our own witness expert, who went down to the police department, where Montgomery, who extracted these texts already for the police department, and which Savelli used in the course of his investigation. So our expert went down and did the same thing through his own program. We had to call that person in, and we introduced those, and once we tied those up with Mr. Lloyd's testimony, they were introduced. That's the 1 week of text messages, including the last one, which clearly states that his brother attacked him, which they failed to show or introduce because it's bad for them.
Well, without Mr. Lloyd testifying, which the state cannot call Mr. Lloyd, how would that evidence have been equally available to the state? Because it has to be equally available to both sides.
Tried a murder case against these folks, not these two prosecutors, two other prosecutors, where they called their phone guy, he downloaded everything, all the phone numbers, all the texts, they were introduced during the state's case in chief. He could have introduced all of this through the state's case in chief.
How?
These phone texts.
How could he have laid a predicate for whose text those belong to?
The Montgomery, the phone from the mother to Savelli, to Montgomery, downloads, has that information in the program, in that 2,200-page report that identifies those. I tried a case against them, Michael Woods.
Did you object?
Of course I objected. It was overruled.
Was I the judge?
You were not the judge.
Okay,
But it
I don't recall it, so I'm pretty sure.
happens every day.
It doesn't matter whether it happens every day or not. Just because a judge lets something in that's hearsay for which a proper predicate has not been laid over objection doesn't mean that that ruling was correct. So the question that I'm asking you is this, all right? Try to focus on the question I'm asking you, which is, these texts were texts between Mr. Lloyd and Ms. Dixon.
Yes.
The proper predicate for introducing text is that someone must identify the text who has personal knowledge of them. Just somebody getting on the stand and saying, I downloaded it all off Ms. Sade Dixon's phone is not the entire predicate. The predicate requires, let's say it had been her mother getting the text, her mother to say, yes, this is the text I got from Sade. The only way the state could have gotten that in is if Mr. Lloyd, when he did take the stand and say, these were the texts between he and Ms. Dixon. Perfect predicate, and they're in.
That's incorrect, because in this particular case, they executed the search warrant.
Uh-huh.
They not only had her phone, but they have her phone records. It happens every day. Phone records, cell towers.
Okay, the argument of it happens every day is not a legal argument, okay? You tell me, under the evidence code, what the predicate is for introducing a text, and the case law, by the way.
The predicate is, Judge, that if they authenticate the cell phone through the mother, it's given to the detective, downloaded, and it's cross-referenced with what they executed through their own subpoenas or search warrants, which is the records that identify those documents, then they would be able to introduce those texts. End of story.
No, that is incorrect. That is not the predicate for introducing text, if someone objects to them, because somebody has to authenticate the text. State?
I have no further argument, Your Honor.
All right, here's what I'm going to do. Since, if you can find a case that says that that's the predicate, I'll listen to you about the text. But right now, what we're going to do is, we're going to focus on jury instructions. But if you can find a case, I'll revisit it I'm okay with the argument about Detective Savelli.
Just
Hold
so-
on.
just-
I'm not okay with the argument about the text.
One other
Okay.
issue, Judge.
Sure.
Once it's authenticated, this is for Mr. Schwartz, that they become emissions against interest and they could be introduced by the state. They failed to do that, Judge. And so I would ask for the state ruling excluding me after the court has been provided those two cases from arguing that the state failed to introduce those because they were bad for them and we had to introduce them ourselves. And if the court wants to rule that way, that's fine.
What the court is telling you is that I'm giving you an opportunity to provide me with case law that says that the predicate for that introduction is as you say it is, and that a person who can identify those texts, the specific text, not the phone they came from. If they were being introduced against Sade Dixon, that would be one thing because they came off her phone. The issue is they were being introduced, they would have been introduced against Mr. Lloyd, and that would require Mr. Lloyd's testimony, unless I'm confused about what you all were using this for. Mr. Buxman, is there something you want to say?
No, Your Honor.
So all I'm doing is telling you to, find me some case law on this, and then I'll issue my ruling. All right. Anything else?
Yeah, I would like to comment that they failed to call voted the overfield to introduce the ballistic projectile that was recovered. We had to call.
Mr. Buxman? You're talking about the projectile discovered on the other side of the crime scene? You have an objection to that, Mr. Buxman?
Well, the state also did bring out through its firearm analyst the results of the comparison of that projectile to the jury.
So you're objecting?
Yes.
So you didn't introduce the projectile, but you introduced the firearms analyst saying that it couldn't be compared to anything?
I didn't hear you, Your Honor.
You didn't introduce the projectile, but you introduced the firearms comparison?
Correct, Your Honor. We did not introduce the actual projectile. We introduced the results of the comparison of the projectile. That's correct, Your Honor.
Which one of you is arguing? Is it you?
They did that, Judge, because they wanted to hide the fact that it was a sloppy investigation, that their lead crime scene investigator didn't even ask to go to the scene as refuted by our witness and do the proper procedure for collecting that piece of evidence. That she told Overfield just to collect it. He collected it and brought it there. There was never any effort to make to determine where it was found, what condition it was found, photographed, the way they do things with the other projectiles that were on the other side of the crime scene.
But that argument is different than arguing that they failed to call Overfeld, because their CSI person, whose name I can't remember, testified that she got the projectile from him. She didn't go to the, you cross-examined her quite vigorously. Hold on. She said she didn't go to the crime scene. She didn't pick it up. There is nothing that you're saying that wasn't introduced in the state's case in chief other than the physical projectile itself. And they introduced the fact that it was tested and it didn't match either weapon.
Right, but we would have never been able to reference Overfield's collection of that actual thing in the introduction without calling him ourselves. So they basically disenfranchised part of our attack on their case in regards to this particular piece of evidence.
You're losing me again. I'm not sure what you're arguing. What is it that you were prevented from doing by them not introducing the actual projectile?
What they're asking you to prevent us from arguing is that they didn't want you to know all the facts. And they chose not to call this witness who collected the item, who introduced the item, which we had to introduce through him, because they wanted to present half a story. And that's our argument.
And you're objecting to that argument? State, I'm sorry, so I can be clear for the record who I'm talking to.
and I don't quite follow the defense's argument. However, the court also limited the amount of evidence and the type of evidence we could introduce through the Williams rule. So it was limited to an exchange of gunfire. We introduced evidence of the casings, which were the point that was matched to the defendant's gun, which was the purpose of the Williams rule itself. This projectile wasn't even matched to anybody. Therefore, technically, it falls outside the scope of the court's Williams rule allowance.
I'm not 100% sure I follow either side's argument, but again, I'm going to let this one in just because I think you can argue it on
Yes, Your Honor.
rebuttal. All right? Okay, and I'll reserve on the text messages until I get something from defense. All right. Okay. Charge conference. Everybody got their jury instructions up?
Yes, Your Honor.
Who's doing jury instructions for defense? All right, I assume there's no objection to 3.1. Counsel may remain seated throughout charge conference. 3.2, statement of the charge. Any objections? Hearing none, I'm moving on to 7.1, introduction to homicide.
Your Honor, the defense has indicated in justifiable homicide, they wanted the last phrase taken out, which says, or to commit a felony in any dwelling house. I agree it's not applicable to this case. However, I do get a little concerned about modifying a justifiable homicide instruction in light of all the case law surrounding not giving that completely.
While resisting an attempt to murder or commit a felony upon the defendant. So the language that we're discussing is, quote, or to commit a felony in any dwelling house in which the defendant was at the time of the killing, period, close quote. And defense is requesting that it be taken out.
It's unnecessary, Judge. There's no evidence that he was in a dwelling house at the time of the offense.
Yeah, there's a lot of cases that reverse courts for messing with the justifiable homicide jury instruction. What's the harm if it's read? Because it doesn't apply.
This is not a big deal. For us, it's just
Yeah.
if there's any surplusage that they're going to have to consider, we'd rather them not have to go through and say, oh, this applies, that doesn't apply. That's all.
I don't disagree that there's no evidence of this. So they repeatedly told us that we can take out things that there's no evidence of. So at the request of the defense and the defense understanding that they're entitled to have this read, I'll take it out. So it now reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, period. Is that what you're requesting, Mr. Schwartz?
Correct.
All right. Excusable homicide. Any objections to excusable homicide?
No.
All right. Count one, murder in the first degree.
Just trying to vote on it. Yep. Thanks.
Okay, you need to take off all the bold.
Remove that?
Yeah, you can't bold things in the middle of instructions.
Oh, absolutely,
Yeah.
Your Honor. I did that for our purposes.
Oh, okay, all right.
And these are areas that I wasn't sure if the evidence would support. It was easier to take it out than add it.
Oh, okay, perfect.
I will
I understand
unbold
that
that.
now, so, all right. Didn't know. All right. Defense, you want to be heard on this instruction?
For count one, Judge, we're fine. with
Yep. Premeditated murder. The part that's bolded, for the entire instruction on first degree.
it. Well, the part that's emboldened, we want to remain in there, Judge, as you said, just not in bold. I think there's plenty of evidence presented that heat of passion is a reasonable consideration.
Okay. Yeah, other than removing the bold, you're fine with that one. Count two, murder in the first degree, unborn child.
The defense has indicated in element 3, they would like the words "of the unborn child" added. I have no objection to that, and with court's permission, we'll add that. It'll say the death of the unborn child was caused by the criminal act of Markeith Loyd. And I will obviously unbold the heat of passion section.
Did you guys just modify the standard for the standard first degree murder for this one?
I did, Your Honor. There is no standard instruction for this, so
Okay, I just want to make sure, because I could not find a standard instruction for this statute.
I
So element 3, you would say the death of the unborn child was caused by the criminal act of Markeith.
yes, ma'am.
Okay. Any objection from defense?
No, Judge.
Okay, with that change, that one's approved. All right, introduction to attempted homicide. All right, I have an issue with this one that I marked. If you read paragraph 3 under 6.1 that begins, if you find there was an attempted killing of Ronald Stewart, Dominique Dixon, or Stephanie Daniels Dixon, You will then consider the circumstances surrounding the attempted killing in deciding if it was attempted felony murder. You charged Mr. Lloyd with attempted premeditated murder in Mr. Stewart's. Count 3 is premeditated.
Honor.
It's not felony.
That's correct, Your Honor. I will, if I change it to if it was attempted premeditated or felony murder,
Defense?
It would be attempted premeditated murder then.
has to count 3, but attempted felony murder has to count 4 and 5.
He's charged with felony murder in 4 and 5.
No, that's fine.
So it would then read, in deciding if it was attempted premeditated, let me,
Well, I guess you need to distinguish then, you might need 2 paragraphs for that, Judge.
yeah, this is, what about if we did something as straightforward as if it was attempted premeditated murder of Ronald Stewart or attempted felony murder of Dominique Dixon or Stephanie Daniels Dixon?
Yes, ma'am.
Well, I guess, Judge, then you still have to do something to just clarify in that 3rd line that the attempted premeditated would apply to Ronald Stewart only.
That's what I said. If it was attempted premeditated murder of Ronald Dixon, or if it was attempted felony murder of Dominique
Okay,
Dixon and,
that's fine.
okay. For the record, it appears to me that Mr. Lloyd is sleeping. Mr. Lloyd, are you awake or are you falling asleep? Okay. Is it because you're not particularly interested in jury instructions, or you're just having trouble staying awake? I can't hear you. So you had trouble sleeping last night? Okay. If we got you some coffee, would that wake you up? All right, so why don't we take a break? Can we get him some coffee? We can't? SRT has to? Can you see if SRT will authorize him drinking a cup of coffee? If that's a problem, let me know, because he needs to be awake during jury instructions. Okay. Let's see what they can do to help him wake up. While we're waiting for them to come up, since this is a minor one, on the next one, justifiable attempted homicide, are we taking out or to commit a felony any dwelling house in which the defendant was at the time of the killing, just to make it match the first one? Defense?
That's
Justifiable
fine, Judge.
homicide, attempted. Same?
Yeah, we would just take out the dwelling house section.
Any objection from state? This is standard instruction being modified.
Removing that last phrase to make it match.
Or we're taking out, quote, or to commit a felony in any dwelling house in which the defendant was at the time of the killing, period, close quotes.
Yes, ma'am.
Okay. Great. Okay, so Mr. Lloyd's awake right at the moment, so I'm going to keep going. Is the, SRT's coming up to discuss something. All right, excusable attempted homicide. Any objections from either side? Or changes? Mr. Schwartz, you have any changes to that?
No, Judge.
State, you good with that? Okay. All right, so that instruction has been okayed with the changes that we already made. 6.2, attempted murder, first degree, premeditated. This is as to Ronald Stewart. All right, in the court, for the record, the court is making sure that Mr. Lloyd is awake while all this is going on. Any objections or changes to count 3, state?
No, Your Honor, I'll unbold that.
Okay. Defense?
No, Judge.
Okay, that one's approved.
Well,
I'm sorry?
no, I'm sorry, I'm mixing 3 and 4. Nothing for 3, Judge.
Okay. Count 4, attempted felony murder, enumerated felony.
The defense has requested a definition of act to include a series of related actions arising from, performed pursuant to a single design or purpose. I will add that in there, I agree.
All right, tell me again what they're asking?
After the paragraph towards the bottom that starts with a premeditated design to kill,
Yes,
there is a section in 7.2, first degree murder, that defines what an act is.
Right.
I did not include that in this.
Okay.
I will.
all right. Gentlemen, good afternoon. Mr. Lloyd is having difficulty staying awake, apparently. He didn't sleep well last night. I need him to be present during jury charge conference. He wants to be present. Is there any way that he can be given either coffee or a soda that has caffeine in it, something to wake him up, or is that not possible? No, I'm saying if he's fine with drinking coffee while he's, all right, so can we give him a cup of coffee, please? All right, let's, they're going to go get him, so defense going to go get him some coffee? Yes. All right, great. Thank you. Thank you very much. Sorry to have you come on up. Mr. Lloyd, you awake enough to keep going for right now? Okay, he's indicating he is. All right, let's do count 4. So we're going to make the change to go back to the standard language in 6.3.
Yes, Your Honor.
Judge, at the very end of that, we had suggested adding in that the intent to kill and then adding in the name of the victim. We don't need to do that. It's fine as the state had it.
So do you not want the name in? Or?
Whatever you want. It doesn't matter for us.
The standard instruction does not include the name of the victim in that last sentence. That's why I left it out.
The standard is fine, Judge.
All right, so for the record, beginning with the paragraph that begins, a premeditated design to kill means, tell me where you made the change and read the change into the record, please.
Yes, Your Honor. Following that paragraph, there'll be a new paragraph which says an act is in quotation marks, includes a series of related actions arising from and performed pursuant to a single design or purpose.
Okay.
We'll add that phrase in there, and then the next paragraph will resume with an act is imminently dangerous.
And the remainder of the instruction will
Correct,
stay
Your Honor.
as proposed. Any objections from defense?
No.
Any further additions requested by defense?
Nothing, Judge.
State, you okay with it now?
Yes, Your Honor.
Okay. All right. Count 5, I assume same change being made on this one?
Yes, Your
Is
Honor.
that correct? Defense?
Same thing here, Judge, and same thing regarding the remainder for the standard.
That you're fine with the name not being there?
Correct.
Okay. .4, lesser included crimes or attempts. All right. Count 1, second-degree murder and manslaughter. Anything else being requested by defense?
No, Judge.
All right. So you broke these up? All right. Count 2, or I'm sorry, the way you all did this is you have the lesser includeds broken up by each count.
Yes, Your
In other
Honor.
words, you're repeating 3.4. You don't have to stand during this, Mr. Buxton.
Sorry.
Thank you. Okay. I just want to make sure for the record that we're clear on this.
Yes, there is a separate lesser instruction for each count.
Okay. So 7.4, murder in the second degree, this is all as to count 1.
Correct.
Any changes requested by state,
No, Your Honor.
defense?
No.
Okay. 7.7, manslaughter as to count 1.
No changes by the state.
Nothing, Judge.
Okay, so those are all the lessers as to count 1, and those two appear to be fine. All right, lessers as to count 2, first-degree murder of an unborn child, it's second-degree murder of an unborn child, manslaughter of an unborn child. Any others requested by defense?
No, Judge.
State, are you requesting any other lessers on either count 1 or 2?
No, Your Honor.
All right. 7.4, any changes requested by either side?
I will add in to element 3 the same as we did to the main charge. It will read the death of the unborn child was caused.
Okay. Any other changes requested by defense?
Nothing for us, Judge.
State, you're good with this one? With that
Yes, Your
change?
Honor, state's
Okay.
good.
All right. Manslaughter,
Same thing, element 3, I will add
Okay.
that phrase of the unborn child.
Yeah, could be a problem.
other than that, any changes requested by defense?
No, Judge.
And state, you're good with it with those changes?
Yes, Your
All right,
Honor.
thanks. Lesser included on count 3, attempted first-degree murder, attempted second-degree murder, aggravated battery, attempted manslaughter by act, felony battery, and battery. Defense, you requesting all of those?
We are not, Judge. I don't think we need anything other than, we don't need battery, felony battery for sure.
You don't want felony battery or battery state. You have any objection? Those are Cat 2s anyways. You have
No
any
objection,
objections?
Judge. I
All right.
added all the lessers that conceivably could fit.
It's easier to delete than to add, so I agree. All right, so felony battery and battery will not be read, so we would then have attempted second-degree murder, aggravated battery, and attempted manslaughter by act. So, so, attempted second-degree murder, attempted manslaughter by act, and attempted aggravated battery are all Category 1s. There is a fourth Category 1, which is attempted battery. State, you waiving attempted battery?
Yes,
Category
Your
one?
Honor, and attempted aggravated battery, because I don't think there's any evidence in this case of an attempt. It's either I don't think it's in dispute that Ron Stewart was shot.
Okay. Mr. Schwartz, is the defense waiving attempted aggravated battery, Category 1?
Yes, Judge.
And are you waiving attempted battery, which is a Category 1?
Yes, Judge.
All right, based on the waiver by both, we can take those out. So now I have attempted second-degree murder. Is that being requested by either side?
Yes, Judge.
Aggravated battery, is that being requested by either side?
Correct.
And attempted manslaughter by act, either side requesting, it is a Category 1.
Yes.
Okay. Any other lessers requested by state?
No, Your Honor.
Defense?
No, Judge.
Okay. All right, attempted second-degree murder, 6.4. This is Esther Count 3, Ronald Stewart. You are going to make all the fonts the same, right?
Yes, Your Honor. I'm not sure why the font of 1, 2, and 3 is smaller, but I will. Mr.
Okay.
Schwartz pointed that out also.
Any changes requested by state or suggested by state to this one?
No, Your Honor.
Defense?
No, Judge, just a
All right.
bold.
There's that double period at the end, yeah.
Yes, ma'am.
All right, aggravated battery, 8.4.
The defense has requested a definition of great bodily harm. They are requesting great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I don't think it's a standard instruction, but I have no objection to adding that in.
Yeah, it's part of it, it's sort of part of the standard. That's fine. Anything else requested by defense?
No, Judge.
All right. 6.6, attempted manslaughter by act. Any changes requested by state,
No, Your Honor.
defense?
No, Judge.
Come on. Okay. Felony battery, that one's not in anymore, and battery's not in. All right, count 4, attempted felony murder. There's actually more category 1s to attempted felony murder. So, let me go through those with you all. You all have attempted manslaughter by act, which is, no, I'm sorry, this is the only category 1 for this one. Any category 2s requested by state?
No, Your Honor.
Defense?
No.
Okay.
And if the court wishes, I can combine that lesser and do one instruction for 4 and 5.
Yeah, I don't think we need to read this twice, yeah. Right, that's all the lessers. So there's a style change I want you all to make, because I found over the years it's easier for the jury to follow this. You just need to come up here and I'll show you what I'm talking about.
Are the lessers of attempted manslaughter by act for counts 4 and 5 appropriate?
Are there any changes to that?
No.
Okay.
Okay. Come up here. I'll talk loud, no, I'll talk louder. I just need to show it to you. I'm not crazy about the statutes being in there, but it's not enough for me to worry about it. When you get to these lessers,
Let's see what's on the false sweeper in this.
oh, no. I'm going to explain to you how I'm going to read this. I'm not reading this over and over and over again. And I'm not required to try to do that front of a million times. On that, count 1, put in count 1, so
Okay.
they can follow what you're doing.
No problem.
Especially when you get to the attempted manslaughter one that we just talked about.
If I put as to count 1 or something like that. is
You
that-
can do that, you
Okay.
can do it this way, as to counts.
For whatever it's worth, I think it's usually clearer without the statutes in there.
I normally take the statutes out just because the less verbiage they have to look at. I've had jurors come back and ask me, do I need to do something with this number? So
Yes, ma'am.
I try to simplify it for them, but if you'll just put it in parents as to count 1, count 2.
Absolutely.
It really helps the jury follow what you're supposed to be doing. Did you hear all that, Melissa? Or do I need to repeat it? All right, so to the extent I've shown it to the lawyers, we're going to remove I take it we're removing the statute numbers, correct? And we're going to add in parents on the lesser includeds, referring the jury to which counts we're talking about. For example, as to count 1, as to count 2, as to count 4 and 5. All right, ready? 3.3, possession of firearm, discharge of a firearm, or discharge of a firearm causing great bodily harm or death. This is the enhancer. It's murder in the, I'm sorry, yeah.
I guess if judge as it stands, it might get a little confusing because you have all the
This is,
charges together and then you have the 3 different
well,
victims.
there's a couple of issues that I just want for the record. First of all, count 1 of the indictment charges this with a firearm. So this doesn't match the indictment.
Correct, Your Honor. I actually removed that because obviously it doesn't affect the sentence in any way if
Right.
that's the jury's decision.
I just wanted to be clear that first-degree murder is, he's indicted with a firearm, but this instruction does not deal with that. I mean, you're legally correct. It doesn't matter. If it's first-degree murder, it's first-degree murder. The firearm doesn't matter one way or another. But it doesn't match the indictment. I don't know if the defense is requesting that it match the indictment or has any objection to this.
Are you talking about going all the way back to the first instruction we talked about, Judge?
No, I'm talking about possession of a firearm.
No, there's no need to put it in.
You're fine with it? Okay.
Fine.
So,
In the second paragraph, I noticed I still included first degree in there.
well, you also put in, well, attempted murder, no, you, attempted murder in the first or second degree. It's not. You have murder in the second degree, attempted murder in the first or second degree, attempted felony murder or aggravated battery.
In the next sentence.
Oh, there it is. Yeah, I'm sorry. This instruction is incredibly confusing.
Judge, I think in the first paragraph, we're probably going to need to distinguish between who are the victims and the offenses, because the way it's written now, it can get a little bit jumbled. For example, let's just say the jury says he discharged a firearm and caused great bodily harm to Ronald Stewart. They shouldn't find him guilty of murder in the second degree. But the way it's written here,
No, the instruction is inherently confusing, is the problem, okay? This, especially when you have multiple counts to which the firearm applies. So what we need to figure out is a way, without going too far, to break this down for the jury so they understand what they're supposed to be doing. All right, so committed the crime of murder in the second degree. We could always utilize my handy-dandy parents and say, if you find that Markeith Loyd committed the crime of murder in the second degree, and put in parents as to Sade Dixon, then comma, attempted murder in the first or second degree, parents as to Ronald Stewart, which at least identifies who we're talking about, or aggravated, except that, what happened to attempted felony murder in the first paragraph? We seem to have lost attempted felony murder in the first
We
paragraph.
did, Your Honor.
This instruction is just a problem when we have multiple counts like this. I agree with the defense that we need to tell the jury which alleged victims belong to which of these, what are in essence lessers for some and not for others, because the aggravated battery is a lesser, and it can apply to that only applies to Ronald Stewart.
Your Honor, what I can do is I can modify this instruction with the guidance by the court and what the defense wants, and email it to everybody, and that way, rather than trying to create it, we can kind of fix things that that the court or the defense doesn't like in light of the judge's, in light of your instructions.
Oh, right, we're not going to, all we're doing right now is going to draft number 2, so that, because once you do all these changes, we're all going to need to look at it one more time before we go to a final draft, and I'm trying to go as fast as possible so we can do that this afternoon, so you can get everything printed, and we can have it all back.
Yes, ma'am.
We can be ready to go at 9 a.m. So my suggestion is that we add parents as to each victim, and you need to re-add attempted felony murder in paragraph 1.
Yes, Your Honor.
Defense, what's your suggestion?
I think we may still have that issue with the last clause beginning with "you should find the defendant guilty of." It's still technically, even with parentheses, would read that you find Ronald Stewart, then in parentheses, and you put his offenses, you still have "you should find the defendant guilty of murder in the second degree," following right after that.
That's the standard language. What is it that you're asking, that the victims be re-identified in that paragraph?
It may be easier to just break it up into 2 paragraphs. One paragraph for Sade, Dixon, and the unborn child, and then the offenses related to that. Then a second paragraph for Ronald Stewart and his offense.
And you still have to deal with the attempted felony murder counts also.
It's a, I mean, it
I
potentially
don't-
is a long one, Judge.
Yeah, I don't have an objection to breaking it up for, like, do Ms. Dixon and the unborn child in paragraph 1. That's what you're suggesting, and then Ronald Stewart would be paragraph 2, and then Dominique Dixon and Stephanie Daniels Dixon would be paragraph 3. Because they're the attempted felony murder. You can, and the attempted, well, does attempted manslaughter by act, I haven't seen one of those in years. Attempted manslaughter by act doesn't have a firearm enhancer. Okay, that's
No,
right.
Your Honor.
Manslaughter does, but attempted manslaughter does
Manslaughter,
not.
a
Yeah.
thing. It's not a 1020 life crime, manslaughter.
Well, no, but there is a firearm.
enhancement.
There's an enhancement for a firearm.
Correct, that's a different
Under
instruction, which is
manslaughter.
next.
Right, okay. We're getting to that one? Yeah. Okay, that one's going to require some work. And for the record, coffee was brought to Mr. Lloyd. All right, let's move on from that one. Aggravation, anything else on that one?
Not from my
Okay, the rest of it's pretty standard. 3.3A, aggravation of a firearm of a felony by carrying a firearm. This is the attempted manslaughter or attempted manslaughter by act. You need to take out the him, her.
Yes, Your Honor.
I point that out because it's the only easy thing to fix in these instructions. A firearm is legally defined. Any proposed changes to that one?
No, Judge.
Okay.
Do you want me to add the victims in parentheses there?
I think this one isn't as confusing. The other one is confusing because of the sheer volume of charges. So I think we're okay with this one.
Okay.
Defense, you asking for the victim to be added? Thank you, Michael.
Maybe just for, so we have consistency with the prior one. I guess it wouldn't hurt to add the victims.
I don't have any strong feelings one way or another. If y'all want to add the victims and make it consistent, I'm fine. All right, definition of a firearm.
I'm not sure that's needed since it was just read in the previous
I was going to
instruction.
say, it's part of the instructions, so you've got it in the other one. I never got to that point. Did you have it in the other one? Yeah, it's in there.
Yes.
Right, okay. I don't think you need this, the separate reading of definition of a firearm. Plea of not guilty, reasonable doubt, burden of proof. Okay, that last line, if you have a reasonable doubt, it needs to read, comma, you must find the defendant not guilty, not you should find. If you have no reasonable doubt, you should find the defendant guilty.
Yes, ma'am.
Any other changes requested by either side?
No, Judge.
Weighing the evidence, 3.9. All right, let's go through this. 1 through 5 are standard. 6, witness been offered or received any money, preferred treatment, or other benefit.
I think the defense brought out with Mr. Stribby that he had pending charges.
Okay. Defense, you're requesting 6, I assume?
We are.
7, pressure or threat. I don't remember anybody being threatened.
I don't know of any evidence to support that, but I'll leave
We'd
it up to the
still
defense.
ask for a judge for the same reason as 6. It would be for Sturby.
Yeah, you get 6 for Struby, but I don't know of any law that says you get both just because someone's been offered a deal or might have been offered a deal. He said he wasn't. You guys say he was. I mean, that's an argument for the jury.
Sure, but that's why I think we should still be able to get the instruction on that one, Judge. I think they go together for this particular instance.
State?
No
had-
opinion, Your Honor.
What?
I have no opinion.
What testimony was that he was pressured or threatened?
He was questioned, at least in terms of, in addition to the deal, Judge, I think there was questioning that at least goes along that line. It may not have been entirely
Tell me what the
correct.
specific, this general isn't going to work. You need to tell me specifically what testimony there was that he was pressured or threatened.
He was promised.
That's 6. He was promised preferred treatment.
Correct.
Now, we're talking about pressure or threat. Was there any testimony that he was pressured or threatened?
No.
Okay, I'm not reading 7. Thanks. All right, 8, there were, 8's in, that's the prior inconsistencies. Convicted of felony. There was nobody convicted of a misdemeanor. So normally I just cut it off and said, has a witness been convicted of a felony? But I can read the whole thing if y'all want. It's up to you.
I'll defer to the defense.
You want the
No,
whole thing
Judge,
read?
I don't recall misdemeanors coming up.
All right, so has the witness been convicted of a felony? Witness have a general reputation for dishonesty or truthfulness? I don't remember anybody.
No evidence of that.
No, there was none of that. Okay, so 10's out. Okay. You see that weird C in the middle of, with the exception, with one exception, where experts are?
Yeah, I do, Your Honor. The defense pointed that out. I have no idea where that came from, but I will
Fine.
fix it.
Yeah,
And obviously unbold and unitalicize
okay.
those sections.
The witness with more testimony, this defense is arguing that Mr. Struby got favorable treatment, so I think that one needs to be read. State, you want to be heard on that? Are you objecting to it?
The bolded paragraph?
Yes.
No, I think that's relevant.
Okay. Defense, you are asking that to be read, correct? Defendant has become a witness, so that one stays in. Entirely proper for a lawyer to talk about witnesses, to talk to a witness. And then, any other changes to 3.9? Okay. Defendant not testifying obviously comes out.
Judge, I know it comes out, but we'd like for that first paragraph to go in somewhere.
That's what the reasonable doubt presumption of
Correct, Judge.
innocence
but this-
paragraph is.
The way that it's written here is very clear, and I think it is very accurate. I think there's a benefit to putting it in as part of the reasonable doubt instruction then.
I believe that the reasonable doubt instruction has been ruled to be more than adequate, so I'm not modifying the reasonable doubt instruction. 3.9B, defendant statements. I don't recall any statements.
There's no formal statement to the police that have been introduced. However, there have been defendant statements. I'll defer to the defense on whether or not they want this.
Okay.
No,
You don't want this one in?
no.
Okay.
I don't think there's a need, Judge.
All right. Eyewitness identification. I don't think this is an eyewitness identification case, but defense, are you asking for this?
We are not.
Yeah, this isn't an ID case. So 3.9C is coming out. 3.10, rules for deliberation. Take out 7. I don't
Yes.
allow jurors to ask questions.
That shit was pretty good.
No comment? Any other? That motion is denied, Mr. Lloyd. Thanks. But thanks for letting me know. All right. All right, 3.11, cautionary instruction. That's pretty standard. Oh, I'm sorry, any other changes, 3.10? Mr. Schwartz?
No, Judge.
All right, 3.11, cautionary instruction, that's a standard. 3.12, verdict.
The defense pointed out a typo at the second to last paragraph. They are as follows as opposed to they as.
Yeah, they are as follows, and then take off the parents,
Yes.
since the jury gets a copy of this. I only give them one set of verdicts. They can each have their own copy of the instructions, but only one set of verdict forms goes back. Any other changes to verdict? No. I'm skipping to 3.12. I'll get to the verdicts in just a second. 3.12, single defendant, multiple counts or informations. Just put single defendant, multiple counts, take out that comma, and take out or informations. I don't want the jury to think that there's more.
Yes, ma'am.
And there is no legally interlocking count in this one, so we need to take out except as explained in the instruction for legally interlocking counts.
You want me to take that out?
Yes, there is no legally, is there a legally interlocking count in this
Well,
one?
the felony murders are based on the conviction of murder.
Oh, sorry. I was thinking of the other legally interlocking one where I have to read the instruction.
That's the next instruction in the packet.
You know, this is the first, I've been through this packet 3 times. This is the first time I noticed it. Leave it back, leave it in. Sorry. Because you're right, the felony murders, you've got to prove the interlocking. Okay. 3.12, defense.
For 3, are we on A or D now, Judge?
3.12D.
We're fine.
Okay, that one's fine. Submitting the case to the jury. We don't have bailiffs, we only have court deputies, so if you can change that to deputies, please.
I've already been chastised for that, Your Honor, and
Who chastised you? The deputies?
rightfully so.
Wasn't the bailiff.
In our jurisdiction, bailiffs, we refer to them as bailiffs.
Oh, I know,
Carry
yeah.
a gun, they're sworn.
You can take out the many may have cell phones because, as I've heard on a daily basis, we have their cell phones, laptops, and everything else. Defense, are you asking that to be read?
No, Judge.
Okay. Okay, the exhibits are not, okay, yeah, because the gun is not going back. Neither gun is going back into the jury room. I don't send those back.
Would you like me to specify? Or have you,
Just say some of the exhibits. This jury tends to take things pretty literally, so I would just say some of the exhibits will be sent into the jury room with you. And then I'm fine with if you wish to see an exhibit, please request that in writing.
okay.
Any other changes requested by defense to 3.13?
No, Judge.
Okay.
Well, there was a sentence we added in that's in the standard about going to the bathroom.
About what? Oh, that's right. If a juror goes to the bathroom, they have to wait. Do you know that? You've seen it? It's in the new standard.
I know the defense added that. I
Yeah.
didn't realize that was new. I will add that in there.
If you need it, I can send it to you.
No, Mr. Schwartz provided it.
Okay, yeah. Yeah, so add in the bathroom language, please. I don't know of a more elegant way to put that. 2.1A, that's at the beginning.
Yes, ma'am.
Okay. Edited recording, there wasn't. Evidence of other crimes. Are you all requesting I read this again?
We are, Judge, and there's the last sentence is missing. However, the defendant can't be convicted. And I think we scratched out the word similar in the first sentence and put in other.
Well, I read it, here it is. You gave it to me twice. One is correct, and then this one is not. I don't know why.
I know one is for when the evidence is to be admitted, another one is for be read at the end of the case.
I'm sorry, you're right, this is 2.4. 2.4 reads, you just need to change the pronouns on it. The evidence which has been admitted, so, here, I'm going to make this easy for you. I'm going to modify 2.4. Just because it has everything on there. Here's, if y'all want to come up here and look at this, this is what I read to them at the beginning. I just changed it to, it's a modified form of 2.4.
Okay. Can I keep this?
Yes,
Thank you.
you may. That work for the defense, Mr. Schwartz?
It does, Judge.
Okay. That obviously will be read before 3.13. All right, 2.6, use of transcripts or recordings. I
Not
don't,
relevant, Your Honor.
I'm sorry?
It's not relevant.
Okay. Then I have justifiable use of deadly force.
The defense has provided me a completed justifiable use of force instruction. I've provided just the bare bones as it came out of our system without
Right.
anything added. The defense has actually filled it out and included what they wanted to read. I can modify when I present.
Do I have that one? Yeah.
You do not.
Okay.
We sent it, Judge. You probably got it about 4 this morning. If you have 2 piles, if you were given 2 instructions, one of them would have that.
Normally my J checks all that and sends it on to me, and she hasn't sent it to me. That doesn't mean we didn't get it. She just may have missed it. Let me see. So you sent it to 21 Orange?
Yeah.
She just did not send it to me, so let me take a look at it. Oh, this is an entire set of instructions.
Right.
All right, I'll get to that in just a second. So you're modifying 3.6F to what the defense requested?
I will, Your Honor.
Okay. Let me find that. Okay, if everyone will go in this proposed 3.6F to the paragraph that begins, Markeith Loyd was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or bodily harm. What I'm getting at is the line that says, if Markeith Loyd was not otherwise engaged in criminal activity, we have a convicted felon in possession of a firearm. which because the counts were severed, the jury doesn't realize that that is criminal activity, but he's entitled only to a modified version of this, not to the criminal activity one, as I understand it. Because him being in possession of a firearm, 2 of them actually, is a criminal activity. And he does not have a right to stand his ground under the Florida Supreme Court ruling and the statute that was in existence at the time. This is a 2016 offense. This is after the statute was modified. He has no stand your ground right.
Judge, it would be our position that that's a matter for the jury to decide.
No, it's not. It's the law in the state of Florida. He cannot assert stand your ground.
My concern is that the court in this instance is making the determination of whether he was breaking the law or engaged in criminal activity. We think that should stay in there because that's an issue for the jury to decide. And I recognize the accounts were severed, but so be it.
He testified, look, if the state's not objecting, that's one thing, but he testified that he's a convicted felon 4 times and he was in possession of 2 firearms. I understand your position, your argument, Mr. Schwartz, but state, are you willing to waive this?
No, Your Honor. That is a legal determination to be made by the
Right.
court, whether it's appropriate.
That's a legal ruling, and if you had raised stand your ground, I would have denied it because he's not allowed to raise it. You're now trying to raise it in the jury instructions. So am I making a legal ruling that he's not allowed to raise stand your ground? Yes, I am. I'm willing to listen to you, Mr. Schwartz.
We maintain our position, Judge, that we believe it should be in there, and that would be an issue for the jury to decide.
Okay. The court finds that Mr. Lloyd does not have a legal right to raise stand your ground, and therefore that portion of the jury instruction would be instructing the jury incorrectly as to what Florida law is. So,
Judge, are you, just to be clear, you're striking that paragraph?
no, I'm striking.
Just the last sentence.
I'm striking if Markeith Loyd, wait, I'm trying to read 2 different instructions. I'm reading the defense's proposed instructions. If Markeith, how do you pronounce your middle name, Mr. Lloyd? DeManslow? DeManslow? Okay. If Markeith DeManslow Lloyd was not otherwise engaged in criminal activity and was in a place he had a right to be, comma, then he had no duty to retreat and had the right to stand his ground, period. I'm striking that whole sentence.
Judge, after having you hear that, I think we probably also want to take his middle name out of when we put
I
it
would
in
be
there.
more than happy if you all would take it, because it would take me forever to read it every single time.
Just
it's in
take the
these
middle name out,
instructions.
it's too cumbersome.
Are you
for
okay
them
with
to go
taking it
through.
out, State?
Absolutely, Your Honor.
Thank you. And then again, in the next paragraph, at the last line of the next paragraph reads, however, the defendant had no duty to retreat. That's again, stand your ground. And that has to come out based on my prior ruling.
Same objection, Judge.
Noted? All right, well, in discussing this is again, the defense's proposed 3.6F. Is there any, first of all, State, are you objecting to any other portions of this?
Judge, I've just seen this instruction. I have not had a chance to review it,
All right.
so I can't answer that at this point.
No problem.
He did send it to me over lunch. We had some spam issues as far as the email. It's not his fault, it's mine.
Oh, no, it's not a problem. This is actually going faster than I thought it would. All right, so I'll let you all continue working on justifiable use of deadly force. Modifications so far are those made by the court based on the stand your ground ruling. And that brings us to the verdicts, correct? Are there any other instructions the defense has requested? Because I just got your packet, that the defense has requested
We had...
that we haven't gone over?
Judge, for 2.5, there's a standard that,
2.5?
yeah, it ordinarily, I understand, wouldn't go in at this point, but I would like some instruction. The standard reads, the evidence you're about to receive that the defendant has been convicted of a crime should be considered only in weighing the credibility of the witness's testimony and not for any other purpose. I'd like some version of that here as well, maybe just the evidence that that defendant was convicted of a crime should only go toward weighing the credibility, not for something else.
State.
Your Honor, I believe that instruction is to be read at the time the evidence is being introduced.
It is, Judge. I'm acknowledging that, but I think we can just switch a word or two around and it fits in here. And I think it's important here because there was a lot of discussion about his prior felonies, including the actual nature of the felonies.
Which was brought out by the defense.
Understood. I understand, Judge. The simple fact that there was plenty of discussion from both sides.
The issue of someone's weighing it for credibility is contained in 3.9. State, are you objecting?
Yes, Your Honor, I am. I think it's covered in another instruction. There's a specific instruction dealing with convictions of crimes.
Let me read 3.9 again.
Well, I mean, Judge, this is a sentence that could be added into 3.9.
I'm still trying to find it. Mike.
Judge, if you're going through, it's about halfway through. It's about 52 pages.
Hold on.
in.
Let me read this first, okay? You should consider how the witnesses acted as well as what they said. Some things you should consider are, has the witness been convicted of a felony? And you want to add what?
Well, as it reads, it's the evidence you're about to receive that the defendant has been convicted of a crime should be considered only in weighing the credibility, not for any other purpose. So I would just modify it to say something along the lines of, the evidence you received that the defendant had been previously convicted of a crime should be considered only in weighing the credibility of the defendant's testimony and not for any other purpose. And I think it fits in somewhere within, probably right after, well, my numbers are mixed up, but it fits in 3.9, Judge.
I think 3.9 covers it. It appears redundant. I mean, that is, 3.9, the entire point of 3.9 is how they weigh credibility and weigh everyone's testimony. And quite frankly, some of the evidence, some of the testimony and evidence from Mr. Lloyd about his prior convictions went beyond what is usual in these cases.
That's partly why I think it is important to put in that specifically weighed only for the credibility and that last portion which just says not for any other purpose. Yeah, I think that's something that really needs to be drilled into their heads with this, Judge.
State.
Your Honor, the reason that the defense introduced a lot of this additional evidence was, I believe, to probably show why the defendant distrusted the police, so it goes much more beyond just the credibility of the witness.
Yeah,
and I think 3.9 also covers all of this.
Yeah, his testimony went far beyond what elicited by the defense, for the record, not by the state, but by the defense, went far beyond just what is normally done for so no, I'm going to deny the defense's request to read a modified form of 2.5. All right, anything else that you guys have requested that I haven't covered?
No, Judge.
That it? All right. Any other changes that you requested in your instructions that haven't been discussed? Mr. Schwartz?
No, we went over everything, Judge.
Okay, thank you. All right, verdicts. Count one. First-degree murder, second-degree murder, manslaughter, not guilty. Any changes?
Not by the state crime.
No.
Okay. Verdict is to count two. First-degree murder, second-degree murder, manslaughter, not guilty. Any changes?
No.
All right.
The state has no changes in any of these. I've prepared them, so.
Okay, well, you do on count three, because you have aggravated, you have felony,
Yes.
battery, and battery in there.
We'll-
Okay.
We'll change those.
Thanks. Okay.
Absolutely.
Here's the only question I have on count three.
I think,
Attempted manslaughter by act and aggravated battery are both second-degree felonies? Because you need to flip those, I think.
I flipped them in the lessers. I did not flip them in the verdict form.
Okay, yeah, they need to be flipped.
Aggravated battery should be B.
So you have attempted first-degree murder. This is count three. Attempted first-degree murder, attempted second-degree murder. Then you have aggravated battery, and you have attempted manslaughter by act. It has to go in descending order of severity.
Yes, Your Honor. I'm checking the lesser page.
I think both ag battery and attempted manslaughter by act are second-degree felonies. I know aggravated battery is a second-degree felony.
They are both, I believe, second-degree felonies. I believe ag-bat is a higher level offense.
That's what I was going to ask. What level of, is
I
it
think
a high?
ag-bat's
I haven't done an attempted manslaughter in years, so,
I think an ag-bat is a level 7 and attempted manslaughter is a 6.
okay. I'll check that also because they need to go in order of severity. You appear to have it in the right order, but just check the order.
Yes, Your Honor.
Any objections from defense?
No.
Count four, attempted felony murder, attempted manslaughter by act, not guilty. And count five is the same. Any objections from defense?
Nothing.
Special findings. Count one, any objections from defense?
No.
Special finding, count one, as to manslaughter.
No.
Okay. Special finding, count two. Any objections from defense?
No.
Special finding, count two, as to manslaughter. Any objections from defense?
No, Judge.
Special finding, count three,
No.
and special finding, and that's on second degree, I'm sorry, attempted first, attempted second, or ag battery. And then any objection on attempted manslaughter by act as to count three.
No.
Verdict form. Verdict forms for count four and five. Any objections
No.
to attempted felony murder or attempted manslaughter by act?
No, Judge.
All right, so, Mr. Buxman, how long do you think it's going to take you to make the corrections and send another draft?
You do that a half hour, I think I should be fine.
Okay, so why don't we reconvene, so I don't stress you out, we can reconvene at 4 if you want to do that, because guys might have to chat a little bit, or do you want to reconvene at 3:45?
I'm going to probably just stay here, so
That's fine.
3:45 should work, Your Honor. And if I'm still running behind, if I can let the bailiff know and they can let me
Okay.
know.
That'll give me time to read. I asked my staff lawyer to look at the case law on the text predicate so I can give you an answer before we go. And I got some case law from you all also, apparently.
Yes, sir.
Okay.
Do you, this issue?
Oh, yeah, you know what? I do need to talk to you all about that.
Right,
Okay.
on the sidebar?
Yeah, come on over here. I'll need the court reporter for this. This is an ex parte issue.